Question that we get all the time is, what are the steps when filing a medical malpractice lawsuit? So the first step for you as the individual is finding an attorney. There's obviously a lot of attorneys out there, so you want to do your research and find somebody that is experienced and that you and your loved ones can trust. The next step generally, at least in our practice, is that we have an interview with a client, whether it be over FaceTime or sitting in your living room or coming to our office. We have that meeting just so we can establish a conversation and a dialogue so that you know what your expectations are throughout the life of your case. Once we've signed you up as a potential client, we have you sign what's called a HIPAA release, and we request your medical records. Generally, that takes a few months, just given how these things go with medical providers or hospitals. Once we get your medical records, we review them in-house. As soon as we review them in-house, we send them to an expert who is of a substantially similar certainty to one that you are alleging caused the negligence. Those experts are all practicing doctors, nurses, physician's assistants, C-suite level people, engineers, etc. Those people review your medical records, they review the facts of the case, they review the evidence as we hand it to them, and they determine along with us if this case is viable to move forward. Once we're able to move forward with your case, the first step in the action is what's called filing a complaint. A complaint is basically a skeletal outline of all the things that we are alleging an individual did wrong. Once that complaint is filed, then an attorney is generally retained for the other side, and then they answer the complaint, and then we engage in what's called discovery. Discovery is written documents which help prepare for the deposition and for the case. Once discovery is completed, we generally take what's called depositions. Depositions are a question and answer session between the attorneys and the individual, whether it be the doctor or our clients themselves, where we are essentially determining under oath what they knew, what they should have known, and what they did as it relates to your case. Once that happens, the court usually gives us deadlines in which we have pretrial conferences and mandatory conferences with the court as we move on with your case. The last step in the case is generally trial. Now in Pennsylvania, about 95% of medical malpractice and personal injury cases settle before trial. To the extent that your case does go to trial, that will be the last step in your action and in your case.